So thanks very much. So as mentioned, my name is Joseph DeMarco, and I'm a lawyer that was involved in one of the efforts that have been brought to date so far to address from the legal point of view some of the issues that have arisen with regard to Sci-Hub. And as mentioned in the introduction, I spent a big chunk of my professional career chasing cyber criminals as a federal prosecutor in New York. I ran the cybercrime unit there, and one common thread that I saw as a prosecutor and continue to see today in my work for intellectual property owners is really the quest for the golden key, right? Because if a criminal does not have the golden key, the key that will allow them to access the database that they want, they really don't have much. And there are lots of ways that they can get that golden key. But once they get that golden key, they've got access. And I will tell you that in 20 years now of doing work both in the public sector and in the private sector, I have never yet once met a cyber criminal who set out to gain access to a database for one purpose and only confined themselves to that one purpose once they got inside the database, right? That's not how criminals think, right? A criminal doesn't break into your home just to steal the silver, okay? They break in to steal the silver, the jewels, the electronics, the cash, and anything else worth stealing, okay? They don't think like we do, right? They don't think like we do. If any of you are staying at this hotel, you booked a room, you're staying in the hotel for conference convenience. Maybe you'll watch TV, maybe you'll make some phone calls. You're not hosting kind of an illegal rave, okay, party. That's how criminals think, though. They think that once they get in, whatever they get in, whatever they get access to is fair game. And so, from my perspective, as a lawyer that's worked in this field, whatever you think about open access, whatever you think about what the pricing of articles, books, journals, or newspapers should be, whatever you think about the ability of publishers to deliver content in new and efficient and innovative ways across the digital economy that we live in today, whatever you think about that, always bear in mind that at the same time, the cyber criminals are thinking about it in a very different way. We were retained by Elsevier a number of years ago to seek legal redress against Sci-Hub and its principals in the United States. We filed a lawsuit in the United States District Court in Manhattan in June of 2015, a complaint accusing Sci-Hub and its principals of massive illegal piracy, of violations of federal computer hacking laws, and as well violations of federal laws related to access device, essentially password credential sharing and theft. One of the principals responded to the lawsuit by telephonically appearing or attempting to appear, and essentially admitted to the court her role in the operation of the Sci-Hub platform. The defense that she proffered was that the company was charging too much for its articles, and that information should be free. None of the other defendants appeared. We continued on with the litigation. We were able to persuade the court to serve everyone through electronic means, through email, so we actually were able to bring them before the court, which was an important precedent to set for other future cases. And we were also able to persuade the court to allow us to have authority over other parties besides the defendants who were integral to the operation of the defendant's website. We had tried over the course of many months to persuade some of the TLD, top-level domain name operators, to delink the pirate sites from their registries as a violation of the terms of service. To no avail, they all required a court order. We got a court order. And by getting a court order, we were able to take down, at least for the time being, and we knew that it was only going to be for the time being, the prime real estate of many of these pirate sites. Now, we knew going in that the pirates would not give up. We knew that they would re-register their domains using non-US-based top-level domain providers. They would reroute traffic and do all of the things that they're very, very good at doing when it comes to breaking the law and violating people's rights. And they did, but we felt that it was important to bring the lawsuit to, number one, demonstrate to the court, to the industry, to the world, that what they were doing was wrong, to tell our story about the massive scale of infringement that was going on, to describe in detail the continual, repeated, and very sophisticated theft of access credentials and compromise of university systems, and to make sure that, at least in one place, some account was to be held for this. All of our pleadings are in the public domain. If you see me afterwards and give me a business card, I'm happy to send you a link to where you can get the pleadings. And it tells the story in great detail. So we brought the lawsuit to show that it could be done, that it would be done, that it was important to do, and that it was worth doing. Obviously, there have been other efforts by other publishers around the world to apply local law in different ways. Obviously, national laws are different throughout the world, and there are different remedies available to in different countries to address the problem of piracy. But I would submit to you, and I'm happy to answer questions on this. I know we're going to want to leave some time for questions. I would submit to you that as you think about where entities like Sci-Hub and other entities that seek to make access of paid content available for free, where that should sit in the publishing world, I think it is important to remember, number one, what I just mentioned, that once criminals gain access, they rarely confine themselves, never confine themselves to one type of crime. And number two, that the things that these cyber criminals are doing will not just stop with piracy. You know, when you think about it, all of you in this room have gotten letters from entities that have had your personal data telling you that they lost their personal data. Maybe you were a Target shopper, maybe you were a Home Depot shopper, maybe you had a Sears credit card, maybe you were a Hilton Hotels customer. And at a certain point, you got a letter saying, "Dear valued customer, we write to inform you that while we have no reason to believe that your information has been used to commit identity theft, we nevertheless are required to tell you, et cetera, et cetera, et cetera, credit monitoring, et cetera, et cetera." Anyone in the room not get one of those letters, right? You've all gotten those letters. Why have you gotten those letters? You've gotten those letters because courts and legislators have realized that a simple piece of information, as simple as your name and email address and your password, is the very first step to a very long series of crimes and wrongdoing. It's why the modern trend in data breach laws has states passing laws like California just did, saying to companies and organizations, if you lose someone's username and password, you've got to tell them, and you've got to offer them credit monitoring, you've got to offer all these remedial suites of services. Billions of dollars of our national economic life is being spent to protect your rights in that regard. And I would submit to you that the reason why that money's being spent, the reason why you're getting those letters, is because many people use those credentials not just for one platform or site, they use them across a range of platforms and sites. And I can tell you from having looked at the actual evidence of the actual intrusions that actually occurred in this actual case, that I know for a fact that usernames and passwords were being shared across platforms. And so for those of you at universities who have, usernames of students that have passwords like UConn students, go Huskies, right? Dollars to donut, those passwords, those credentials are being shared by that student across other platforms. So even if you didn't care about your own networks and the integrity of your own networks, I would submit to you it's worth caring about your students. They may be off doing other things, they may not care, but I would submit to you that you should care. So the lawsuit went on. The defendants never showed up in court. They're very courageous online, but not one of them came to show their face in open court, to stand up and put their money where their mouth was, to put their reputation and their pocketbook on the line. Remember, this is a civil case, not a criminal case. They didn't even have the courage to do that. We got a default judgment, and the case is resolved. Other publishers have sued. Small publishers were part of our efforts. It was a collective effort. We were obviously leading on behalf of Elsevier, but we had a number of other entities that were supporting us. But I would submit to you that as you think about this problem, if you perceive it to be a problem, and what the solution should be, you should think about some of the legal issues I've mentioned, some of the policy issues I've mentioned, and some of the reputational, business, and social implications of what's going on here. Thank you.